If you want to enforce the award, that's fine. But if you're thinking about refusing it, first seek the approval of the Supreme Court. What does this do? Obviously, it gives greater assurance that China's approach to compliance with the New York Convention will be considered at the national level, giving the judges at the highest level the occasion to develop an understanding of the subject, and reflecting a very sophisticated comprehension that the New York Convention is not the law that creates a regime for how arbitration awards are enforced or not enforced. The New York Convention is only a treaty for the enforcement of awards. A minimum requirement that in certain circumstances awards must be enforced. What you do the rest of the time, the New York Convention doesn't say. And so this is exactly what the Chinese Supreme Court has understood and implemented in this fashion. Some other recent initiatives have been extremely practical. The ICA conference in Dublin a few years ago it's sort of like Olympic Games. Some are very successful. Nobody who was in Sydney will never forget it. There will never be Olympic Games like Sydney. We all know that. ICA conferences are sometimes highlights and sometimes not. Dublin was wonderful. One of the reasons was an effort by the organizers to engage with the local judges and with the local government. Anybody who was there will remember a speech of the Attorney General, who was there the whole 3 days, not just saying, I bless you all and have a good time and I wish you great success in your works. He was there, and having heard for 3 days, gave a rousing speech. He says, I've understood so many things right now, and I'm going home and I'm going to start working on a bill. Because my lawyers in this country say that this was important. I wasn't sure. I've been with you. Now I get it. It's important. And so, in 2010, the Irish Arbitration Act was amended. In particular, just focusing on this very subject, in particular to enable the appointment by the High Court of what is literally called an arbitration judge, operating under the rules of the superior courts. And this judge has broad powers to give final decisions, no appeal, with regard to applications to staying court actions in favor of arbitration, Article 2, and setting aside or enforcing awards. In the Australian court, and the Australian courts have one state, Victoria, there is a list called List G, the arbitration list, that's what it's called, which is managed by a single judge, pursuant to a practice note of 2010. And this particular single judge is known to many of us, participated in the works of Uncitrol, extensively written on the subject of arbitration, and he is now the arbitration judge for the courts of Victoria. I don't know much at ground zero of how this works, but you see the intention and you see the understanding. These are the phenomena of partnership. Perhaps the most remarkable example of all is that of Switzerland. I hope you know this. All applications to set aside awards rendered in international cases are presented. Any application to set an award aside goes immediately to one place and one place only, the Supreme Court. And the record of the Federal Tribunal is very distinguished. In recent years, it has consistently handed down reasoned decisions within a period of well less than 1 year. 6 months is not rare to get decisions from the Swiss Federal Tribunal. So the judges at that level develop quite a routine of dealing with international cases. They know that their control is essential. They know that it's important. They know that even international users who are mature understand that this is something that they need. Well, Canada would have been pleased to have the Swiss Federal Tribunal sitting in France 20 years ago when they had their misadventure in Strasbourg. So even the foreign users of international arbitration will applaud the possibility of this kind of recourse in exceptional cases, which is what we want to think is the limited case when arbitrators need to be corrected by the courts. When that need arises, We want the courts to be well informed, to be well versed, to have a routine in conducting these kinds of cases. An additional benefit of this kind of specialization, which I would guess takes place in every country where the attraction of specialized courts has been followed, and I don't know of enough of them, but I can speak to Switzerland, where you can observe that the judges of the Swiss Federal Tribunal, who get these cases all the time, not arbitration, international arbitration cases. Domestic arbitration cases go through the ordinary civil procedure system. So the judges of the Supreme Court cases are very aware of the issues that arise in cases of international arbitration. They therefore find it interesting to come to gatherings where international arbitration is discussed. They find it useful if they are given the word themselves, and they speak. And they don't speak in terms of philosophy or generalities. They talk about things that they have seen in practice, and they indicate the kinds of behavior of arbitrators which puzzle them, which is a code word for saying don't do this unless you want to risk censure. Surely that is a very healthy thing. Surely that is a way of introducing a very adult approach to arbitration, particularly in the international sphere, where we can hope to achieve a good balance in the eternal debate that we are seeking in terms of establishing the limits of private justice that claims to get the support of public authorities ultimately to make it effective. I thank you very much for your attention.
Si le gustaría recibir alguna pregunta o algún comentario de alguien, no sé si es el caso. Como es la primera vez que lo hacemos, no tenemos un formato fijo y prefiero flexibilidad ante ello.
Annulled invalidated an arbitral award involving PMIX, and again that was on the grounds that there was the award went against public order. And that decision involved the rescission of an agreement entered by PMIX and the contractor here in Mexico. And that was a very important arbitration which condemned PMIX to pay about $400 million. The Attorney General's attendance to the meeting was sufficient for a high-level government official to understand an issue, whether in the case of Mexico we needed to involve our Supreme Court or our lawmakers to ensure that the Mexican government is taking note. Again, not because this would create a precedent, but because it is a decision which definitely doesn't go in favor of the very good course which international arbitration was taking in Mexico. So that would be my question.
We expect that there are instances where annulment is healthy, but we also expect that when it happens, it should be absolutely clear why the annulment took place, and the arbitration community should understand. Okay, that seems to have been an egregious case. Otherwise, confusion arises, and one wonders whether any award might be susceptible to annulment for reasons that one doesn't understand because it hasn't been clarified. The answer to your ultimate question is, I think, obviously yes. If you think about the country I know the best, I told you about the first president of the French Court of Cassation, who was the president of the whole first session of the very first ICA meeting and introduced this idea on the separation of arbitration clauses. And lo and behold, France became leader of the jurisprudential movement toward this. You don't find cases. You don't find cases in other countries before the French started doing this, and because it was well reasoned and people understood it was really quite a major achievement for France. It's very common to say that France is a country which upholds international arbitration. It's a leading country in international arbitration and so forth. I will say that perception might be true, but this state of affairs is a very fragile state of affairs. It depends on the fact that you have judges like the president of the Court de Cassation at the time, who really takes an interest and feels welcome in the arbitral community. So for years in Paris, this is what my testimony, there has always been a judge at least, and sometimes more than one judge, on the Paris Court of Appeal. Paris Court of Appeal is a bit of a specialized court because international cases in France are in the Paris Court of Appeal. Always one or two judges who take a great interest in international arbitration, and the arbitration community conversely take a great interest in them. So French lawyers, Parisian lawyers will say, have you seen Judge so-and-so lately? I wonder what he thinks of the new rules of the ICC, or I wonder what he thinks of that American decision. Why would he ever look at an American decision? We better send it to him and see what he thinks about it. So there is this sense that one belongs to the same family. One of the judges of the Paris Court of Appeals, it's wonderful, was detached to work in the Secretariat of the ICC for a decade.
En forma inesperada, en dos palabras, se centró y se derivaron lecciones interesantes que quiero decir algo que a mí se me ocurrió mientras las escuchaba. Y es, del resumen de ideas que escuchamos, se escucharon muchas dudas o muchas preocupaciones que hoy estamos viviendo en México. La pregunta de Enrique es muy atinada por eso. Esta rara decisión que se presentó es algo que creo que merece que haya una respuesta, que se genere una crisis para tomar ese capital político, se puede llamar así, y canalizar una respuesta. CAIC está haciendo algo al respecto, lo comunico, a través del grupo de trabajo de 2022 de NAFTA, con diputados y con la Secretaría de la Función Pública. Entonces, si alguien se quiere sumar, es el tipo de tropiezos de los cuales uno puede aprender mucho. Esto en el contexto de contratación gubernamental y el régimen que existe en la Ley de Obra Pública, la Ley de Arrendamientos y la nueva Ley de Asociaciones Público y Privadas. Pero creo que lo que ya nos ha mencionado es muy valioso porque nos hace ver cómo lo que estamos viviendo actualmente en México, que es producto de una sofisticación, de una madurez, yo creo que ya estamos en una etapa madura del arbitraje en México, no es nuevo, y hay lecciones de orientación que nos ha dado Jan, y se nos vienen probablemente problemas más delicados, y tenemos con esta plática una brújula de cómo empezar a no ser, por lo menos yo, tan inocente. Yo nunca imaginé de cómo hacerme rico con el mecanismo de los $50 para evitar lo de las tarjetas de crédito. Veo que aunque sea parte de derecho arbitral, no lo estoy dando todo, no lo estoy explotando todo lo que podría, pero eso a lo mejor no soy el único. Estar abiertos que el arbitraje con todos sus beneficios no es perfecto, como no lo es ningún sistema, y necesitamos tener el radar que en el futuro puede abusarse de él. Quisiera también mencionar que la plática es un excelente primer ejemplo de lo que queremos con la Conferencia Magistral de José Luis Siqueiros. Como mencionaba en mi plática inicial, en beneficio de los que llegaron un poco después, es una plática que lo que busca es una plática excelente sobre un tema recordando a don José Luis Siqueiros, que muchos recordamos con mucho cariño, y haciendo algo de un ideal con el cual comulga CAIC, y creo que fue Popper, no estoy seguro, que decía que una sociedad nunca debe hacer diferencias, ni dar privilegios, sino debe hacer distinciones. Yo creo que en México podríamos aprender mucho de esto, nos la vivimos haciendo diferencias, dando privilegios, y jamás reconocemos a nadie, lo envidiamos, pero no lo reconocemos. Entonces creo que podríamos ganar mucho si siguiéramos este ideal, reconociendo, no generando diferencias, que todos les aplique la ley por igual, y lograríamos generar los incentivos correctos y evitar lo primero que acabo de mencionar, que es corrosivo. Diferenciar es corrosivo, y en cambio lo segundo genera incentivos para superarse. Por último, quiero agradecer de nuevo, Jan, el tiempo que nos ha dado, su plática, y a Bernardo Cortés y a Lely por su excelente organización de este evento. Nos vemos todos en un año. Gracias.